Welcome back to Employment and Labor Law, Legal 267, right here at Edmonds College and their ABA approved paralegal program. My name is Scott Haddock. I'm the professor for this class, and I'm so glad you're with me. This week, before we jump into today's topic, I just want to step back for a moment and connect this to a bigger picture. Now, last week, week one, we focused on the system where employment law comes from, including statutes, common law, and administrative agencies. We introduced the at-will rule as the baseline and identified its major limitations, including public policy. So week one was all about structure, how the system works. This week is going to be different. Now we're working directly with the rules that actually decide the cases. Each lecture this week builds on the last. In this lecture, we focus on termination, specifically when firing becomes legally actionable under the public policy doctrine. In lecture 2.2, we shift to contracts and handbooks when employer policies become binding promises. In lecture 2.3, we're going to examine non-compete agreements under Washington state law. And in lecture 2.4, we're going to move into workplace privacy. So here's the key idea that all four of these lectures together represent. Employment law is not about general fairness. It's about structured legal rules that define the limits of employer power. So as we move into today's lecture, keep this question in mind. When does the law actually step in? Now, I want to be very precise here and avoid any sense that we're merely repeating material from last week. You already learned the at-will doctrine in week one. You also saw it in chapter 2 this week. You learned that under at-will employment, a job can generally be terminated at any time for any reason or for no reason at all, in fact, by both parties. You also learned that the public policy exception exists, and you saw the structure of that doctrine. You were introduced to key cases, including Thompson versus St. Regis Paper Company from 1984, Dycombs versus State from 1989, and Gardner versus Loomis Armored Incorporated from 1996. Now, Thompson, if you remember, shows that employer policies and handbooks can create enforceable obligations that limit at-will employment. Dycombs clarified that a valid public policy must be clearly grounded in law, not just general fairness or personal belief. And Gardner applied the doctrine in a real-world setting, protecting an employee who violated a company rule in order to prevent serious harm. So today is not about introducing those ideas all over again. This lecture is about applying that framework the way the courts would actually use it, the way attorneys would actually do it. And that's an important shift because understanding a framework is one thing. Using it in a way that courts actually use it is something else entirely. So if parts of this particular lecture feel familiar, that's intentional. It's the foundation that you're building on. But what we're doing now is moving from recognition to analysis. So with that in mind, let's go back to the at-will employment rule, but this time as the starting point of a structured legal analysis. Recall that at-will employment is still the baseline. It's the default rule. Employers have broad discretion to terminate employment, and that's where every legal analysis will begin. But here's the shift that I'd like you to make, and it's an important one. At-will employment is not the conclusion, it's the starting point. So when a client says, I was fired, the law does not begin by asking whether it was fair. It does not begin by asking whether the employer made a good decision. It begins with the presumption that the employer's decision is lawful under the at-will employment doctrine. Now, to be clear, this is not a formal burden-shifting framework like you'll see later in discrimination law, but functionally it operates in a very similar way. If the employee cannot identify a legal limitation, something grounded in a statute, a contract, or a public policy, then that claim is going to fail. So here's the working rule that I'd like you to remember. At will means the employer prevails unless the employee can point to a rule that says otherwise. That's the analytical starting point in every case. And once you understand that, the next question becomes the only question that matters. What legal rule limits the employer's discretion? So, if at will means the employer prevails unless there's a legal limitation, the next step in every case is to ask one very specific question. What legal rule limits the employer's discretion to fire someone? That's the question that should drive your analysis every single time. And it's important to be clear about what the question is not. It's not whether the decision was fair. It's not whether it made any sense. It's not whether it was a good management choice. Those are just workplace questions. This is the legal question. What legal rule limits the employer's discretion? And you already know where those rules come from. They come from three sources: statutes, contracts, and public policy. You saw those categories in week 1 and again in chapter 2. Now, we're going to apply those sources. And here's the key point, the one that determines most cases. If you can't identify a specific legal limitation from one of those three sources, the analysis is going to stop. The termination stands. So from this point forward, when you look at a fact pattern related to a termination, your first move should always be, which of those three categories am I in? Statutes, contracts, or public policy? And in this lecture, we're focusing on one of those categories in particular, public policy. Now we're going to focus on one of those categories, as I said, public policy. You've already learned the 4-part test in week 1, and you've seen it in chapter 2, so I'm not going to reteach it from scratch. But you do need the structure in your head as we move forward. So just once again, here's that framework. 1, clarity, a clear public policy grounded in law. 2, jeopardy. The termination would undermine that policy. 3, causation. The employee was terminated because of protected conduct. And 4, absence of justification. No stronger employer interest outweighs the policy. Clarity, jeopardy, causation, absence of justification. Those are the 4 parts of the public policy framework. Now here's the shift. I don't want you memorizing these elements in isolation. What I'd like you to do is see how the courts actually use them, because public policy is a very narrow doctrine. Courts are not correcting every unfair termination. They're enforcing specific, legally grounded policies instead. And that's why most of these claims fail. And understanding why they fail is just as important as understanding why one might succeed. So now let's take that framework and watch a court apply it. Okay, let's revisit that Gardner versus Loomis Armored Incorporated that you learned in week 1. And let's watch the framework for that case in action. Start with the first step, which is clarity with regard to the public policy exception. The court identified in Gardner a clear public policy. Remember, it was protecting human life. Gardner was an armored car driver. The employer said, do not leave your car. He left his car to help a woman who was being assaulted. Now, protecting human life is a policy that's well established, so clarity is satisfied. The next step is jeopardy. Does the employer's rule conflict with the public policy? Here the answer is definitively yes. If the employee stays in the truck, that assault will continue. So allowing the termination would undermine the public policy, so jeopardy is satisfied. Third, causation. Why was the employee fired? Because he left the truck to intervene. The termination is directly tied to the direct causation of the protected conduct. So causation is satisfied here as well. And that leaves us with one last part of the framework. The employee has a rule, but the question is whether it outweighs the public policy. The court in this case said it did not. Protecting human life took priority, and that is the critical move, not fairness, a legally grounded policy that outweighs the employer's directive. Now let's step back. Why does this case work? Well, everything aligns. There was a strong public policy protecting human life. There were extreme facts, and there was a direct conflict. But most cases just don't look like this. In fact, most cases, from my experience in employment law, fail. And that's why I don't take those cases. And that's the key takeaway. Fair does not mean illegal. So the question has to become, how do you apply this framework when the facts are less clear? So let's translate everything you've just done into a framework you can actually use, because this is how lawyers analyze these cases in practice. Step one, start with at will. That's always your baseline. Step two, identify the legal limitation and be precise here. Is it a statute? Is it a contract? Or is it a public policy? And if you skip this step, you'll almost always get the wrong answer because you'll end up analyzing fairness instead of the law. Step three, apply the facts to the rule that you chose in step two. This is exactly what we just did in Gardner, mapping the facts onto each element of the test. And step four, evaluate the strength of the claim. Not just whether a claim exists, but how strong it actually is. Here's the key move I want you to remember. Before you do anything else, identify the category you're working on. Is it a statute? Is it a contract? Or is it a public policy? Because that decision drives everything else that follows. Now let's talk about where you fit into all this, because from a paralegal perspective, this is not abstract. This is day-to-day work. You're gathering and organizing facts. You're reviewing documents like handbooks, policies, communications. You're identifying potential legal issues early. And in many cases, you're the first person to recognize that a situation might involve a statutory claim, a contract issue, or a public policy concern. And that really matters because the way a case is framed at the very beginning often determines how it's developed. So your ability to recognize patterns and to apply this to the framework can shape the entire direction of the case. Now let's bring everything together. So bringing everything back all together, at-will employment is your starting point. That's the baseline in every case. Public policy is a narrow exception, and most claims are going to fail because they cannot meet that standard. And the key question you should always be asking is this: what legal rule limits the employer's discretion? Not what feels fair, not what seems wrong, but what legal rule actually applies. In this lecture, we focused on one path, public policy. In the next lecture, we're going to focus on a different path, contracts. And this is where Thompson v. St. Regis Paper Company comes back into focus from last week. Because that case is not just about public policy. It's also about how employer policies can create binding obligations contractually. So what you learned here becomes the foundation for what comes next. And now you're ready to see how that plays out.